Good afternoon. Somehow this 2 o'clock slot seems to haunt me for decades now. Whenever I have shared a dais or addressed a gathering, it's always been my 2 o'clock session. And Providence gives me this session probably because after a hearty meal, I don't want to put you to sleep. Okay, so thank you for being part of this session. So let us, I saw the MC doing this activity early in the morning. So if you can just all put your hands in the front, and at the count of 3, I want you to clap at one sound, okay? 1, 2, 3. Thank you. That will ensure that you're all awake and excited to listen what we have to unfold for you this session. Today is a fantastic day because today is also happens to be the National Science Day, which is celebrating the discovery of, discovery of Raman effect by Sir C.V. Raman. And what a event, what a auditorium to host this event at the Abode of Science within IISc and J.N. Tata Auditorium. And this area also happens to host the house of Sir C.V. Raman about 2.5 kilometers, 2 kilometers from here. Well, on August 11, 2023, the Government of India under Ministry of Law and Justice enacted the Digital Personal Data Protection Act, in short referred to as the DPDP Act. The preamble to the Act states that an act to provide for the processing of digital personal data in a manner that recognizes both the right of the individuals to protect their personal data and need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. Jargon? Well, that is why the panel is here to make you understand what is this act all about and what are the implications when this act comes into force. Okay, with the ever increasing engagement with social media, like the MC just introduced us, we are all continuously sharing our personal data. So what better way to learn than get to understand from the panel what is this act all about, what implications will it have when I share such data. So let me start off this session and discussion with Venkatesh Murthy. Well, another pleasant news to all of you here is this panel is a wonderful panel because we are all Kannadigas. And this event is hosted on a Kannada news channel. Very rare to see this combination, but I'm happy about it and proud too. So, Venkatesh, the implementation of DPDP Act may take some more time, although the Act is there now. Can you briefly explain the current data privacy framework and how does it differ from or is similar to the data privacy as enlisted under Information Act?
Yeah. Yeah, although this DPDP Act was enacted last year, August 2023, rules are yet to be notified. So if you ask me about the other provisions, the other legal provisions which cover the data protection and privacy, I think Information Technology Act, IT Act 2000, which got amended in the year 2008, it covers widely the data protection and privacy. Especially there are 3 provisions, Section 43A, Section 72, Section 72A. These 3 provisions widely cover the data protection and privacy. 43A specifically talks about compensation for failure to protect data. So the as per Section 46 of the IT Act, the adjudicating authority, the state IT secretary who has the quasi-judicial powers to adjudicate the cyber contraventions under the Information Technology Act, if there is an instance of failure to protect the data, so then the adjudicating authority can award compensation. So although the compensation limit is not set under the Information Technology Act, but somewhere it is mentioned that the IT secretary can award compensation to the tune of 5 crore Indian rupees. So if the compensation exceeds 5 crore rupees, then the competent court may be approached. That is Section 43A. The next very important section is the section 72A of IT Act, which talks about wrongful disclosure of data, means wrongful disclosure of the information which was collected in a lawful contract, which is again very stringent, I can say, which has 3 years imprisonment plus fine is also there. So the body corporate, whoever is processing, whoever is storing the customer data, so if there is a wrongful disclosure without the consent or the knowledge of the what we call data principle in the new act, so then section 72A plays a very significant role. And under the Information Technology Act, section 72 is one very unique section. Section 72, if you speak to police officers who investigate cybercrime cases, you will find that majority of cases, Section 72 is invoked in the FIR. But end of the day, you need to understand Section 72. 72 is not about registering any offense against any individual. The title of Section 72 is breach of confidentiality and privacy. Who is breaching? That's very important. If you read Section 72, it says, whoever having powers under the Information Technology Act, if he has gained access to any electronic record, if he discloses, means a police officer as per Section 78 of IT Act, he has power to investigate, police inspector and above. Likewise, Section 80 talks about power to enter, search and seize under Information Technology Act. So a police officer having powers under the Act, if he has gained access to any electronic record, if he leaks the data, if he discloses the data to any third party, so then the police officer is liable. 2 years imprisonment is there. So under the Information Technology Act, I don't say that it is the complete data protection and privacy is guaranteed via Information Technology Act, but it's like there are some provisions which are already addressed. I think once the DPDP, the rules are notified, Section 43A will be repealed, it will be replaced, and the rules that are made under Section 43A will also be repealed. We are very eager to see the rules and thereafter the successful implementation. Yeah.
Yeah. So some interesting comparisons there. But Akshaya, will you be able to throw us light on what is this processing data and with respect to DPDP Act, and was it already underlined in the IT Act, or are there special provisions provided in the DPDP Act for specifically the share of personal data, because it also specifies word digital annexed to it. So if you can throw us light on the basis of processing data under the new law, and is it voluntary or is it forced, or what is the manner in which it is done? Over to you.
Sure. Thank you for the question. I'm really happy to be here. Like Mr. Venkatesh Murthy already pointed out, there's already some protection under Indian law currently for personal data. And you may be aware that we have an Information Technology Act in India at the moment. The Information Technology Act, under it, there are some rules which are meant specifically to govern how personal data is processed. And when we say processed, we're talking about any kind of handling of personal data. So whether it's collection, storage, indexing, transferring, disclosing to someone, any kind of activity of handling personal data is called processing. And this is already governed to an extent under the Information Technology Act. Now, what is personal data? The way personal data is understood currently and the way that it's understood under the new Digital Personal Data Protection Act is quite similar. It's basically any information that can help identify who I am. So a name is an obvious example. An email ID can help identify me. An address could help identify me and my family members together. So these are kind of the key terms that are used. Now, you asked me a question that's actually encompassing a lot of things under the Act. Basically, the question was, what does the Act do? And I'll give my co-panelists also the opportunity to address it, but I'll briefly say that under the current law, I said that it already governs personal data. It classifies personal data into two categories. So there's things like your name, email ID, address, which is your personal data. But there are certain other information about you which are quite sensitive. For example, your health information or your financial information. What the current law does is it specifically regulates how those sensitive categories of data are handled. So while someone may be able to collect your name, email address, etc. without obtaining your consent, if you have noticed, you will have to select an I consent box or click on a button which says I consent before you provide information like your financial information or health information. What the new law does is it does away with this distinction so that the same protections apply to any category of data.
Okay.
And what it does is it's not forced in nature at all. In fact, the way that you can process any personal data under the new law, once it comes into force, is you will either need to obtain consent, and it explains how this consent has to be obtained and what procedure has to be followed, or you need to fall under one of the other non-consent grounds. For example, if an employer is processing their employees' data, which they need to do for various purposes, to process payroll, to protect the company's IP for a number of reasons, then consent may not be required. Or if you're helping someone in a medical emergency, then you may not be able to practically obtain consent. So except for these few exemptions, the law actually says that you need consent to process any kind of personal data, whether it is name or health information.
Is this consent a discretionary power vested on the person collecting the data, or is it something enforced in the Act?
So the law says that the consent has to be in a certain manner. So it says it has to be free, it has to be specific, it has to be informed, and it should be expressed through an affirmative action. So what that means is that potentially a very broad-based consent may not be accepted. To say that I may collect your data for any purpose may perhaps not be accepted. But what specific means is something that will be interpreted once the law comes into force and we have some interpretative guidance on it going forward. But there is some guidance already under the law.
Thank you so much. So I am sure whenever we have logged into any website which needs a login and a user ID password, or when we are downloading an app which asks a certain data to be submitted before I finally do that, or for the matter when I buy a new phone and start using the app, that app asks me to give permission to access contacts, photos. So otherwise there is no way I can accept the app. So I go on default and do it. But in process of doing so, there is lot of data that is generated by many people. As we speak, I am sure there may be lakhs of data that is coming in. So there is a theory that this data is a toxic asset, and when you have an asset itself, people want to steal it. That is the beauty of the asset. So when there are threats to thefts and fraud prone by this huge data that people own today, how do you handle this? Over to Hemant for throwing some light on this matter.
Yeah, thank you, Narendra. I think now everyone knows in the room why you keep getting these afternoon after lunch slots, because you seem to have some tricks to wake everyone up. Yeah, so this particular term that data is a toxic asset, I think I first came across this term in the work of a public interest technologist called Bruce Schneier. And what he argued was because storage is so cheap and there is so much data going around, it is probably now become cheaper to just accumulate as much data as you can before you can even figure out what you want to do with it.
Correct.
Right? So as a result, what happens is most organizations, for-profit, non-profits, just accumulate hordes and hordes of personal data. They sometimes don't really know what to do with it, aren't quite sure what is the purpose for which it was originally collected, and also don't get rid of it, once that purpose is served, whatever it is. But what I would argue is, there's this American author called Saul Bellow who used to say, every treasure is guarded by dragons, right? Now, if something is precious, then there has to be some way to sort of guard it. Otherwise, it loses its value over time. If everybody's Aadhaar data is out on the internet, then it really doesn't have much value in the eyes of anybody, right? So the important thing is, in order for data to continue to have value and to be a non-toxic, benign asset, what's important is that it's secured. And a lot of the organizations, unless it becomes imperative under the law, don't end up doing that spend on securing the data that they have, because they probably didn't have to work too hard to get it in the first place. And they probably don't have the budget for it this year, or for whatever reason, it doesn't become a priority. Once personal data is with the organization, they don't bother too much about securing it. Now, hopefully, once the DPDP Act comes into the picture and starts to get enforced, that might change. And if it doesn't change, at least in theory, there are some astronomical fines to be paid.
Yeah, I know. Yeah, so going over that threat that the data possesses, and since we talked about security, coming to Venkatesh, one of the main concerns in digital forensics is the potential invasion of privacy that is caused by these data being stored by these multiple platforms. Can you highlight the privacy concerns with the digital forensics?
Yeah. So thanks to Edward Snowden, I can say, because till the time the Snowden's revelations was not there, for us, privacy was bodily privacy. So once these revelations were out in the year 2013, people started worrying about their online privacy, data privacy, and Kevin Mitnick, in fact, he had written a very good book. The title of the book is The Art of Invisibility. How do you stay invisible on internet? And Snowden has also written a blog which talks about how to escape from any government surveillance programs. Bruce Neer, very well-respected cybersecurity researcher, in his book Data and Goliath, he has made a very interesting statement. If you want to make sure something never happens again, all that you need to do is collect data that makes it happen. Okay. If your enemy is anyone anywhere, all that you need to do is collect data from everyone everywhere. Okay. So these are the two very strong statements made by Bruce Neer in his book Data and Goliath. So now, prior to 2013, digital forensics was very much comfortable within the four walls of the laboratory. With the TV shows like CSA Miami, CSA New York, digital forensics escaped from the laboratory. Okay. And these television shows, there was an exaggerated portrayal of digital forensics, and plus the privacy debate which started from 2013. There was the reasonable expectation of privacy was also applied to digital forensics. One is the reasonable expectation of privacy, and at the same time focused queries. When you are dealing with any digital device, so there should be some focused query. Means the investigating officer or the forensic examiner, whoever is handling the data, he should not exceed the scope of the investigation. That is one thing. Second thing is the data related to the third parties who are not part of the investigation. Suppose I may be a culprit, and the enforcement authorities have gained access to my devices. My device might contain personal information of a third party who is nowhere linked with the offenses that has been investigated. So you need to limit it. The third very important item is the recording the accidental or intentional access to personal information. So the privacy invasion, of course, there is enough scope for privacy invasion when it comes to digital forensics. But what we need to understand here is we cannot apply the general privacy reasonable expectation to digital forensics, because most of the time what happens when the investigating officer is investigating a particular case and he has gained access to any electronic device, even though he knows what information he is looking for, he will never know where that information is residing. It may be mislabeled, it may be encrypted, it may be hidden also. Okay, so in such a scenario, I think there are chances of privacy invasion, and let me draw the attention of the audience to the ongoing writ petition in the apex court. There is one case, two cases in fact, two criminal writ petition. One is Ram Ramaswamy versus Union of India, which talks about the SOP, the standard operating procedures with respect to handling of electronic devices by the enforcement authorities. And at the same time, the Federation of Media Professionals, even they have a criminal writ petition which talks about the journalistic freedom. So overall, now the matter has reached to the courts also, that we need the privacy, whatever the assurance or guarantee of privacy that is there for in general, that needs to be applied to the electronic devices that is being dealt by the investigating agencies also. So two, three very important points from the criminal writ petition is one is as far as possible the judicial consent or judicial permission need to be obtained before seizure of any device, which is fair. The second very important item is if the device is encrypted with a password or a biometric, the device owner should not be compelled to reveal the password, or he should not be forced to unlock the biometric lock, which is again debatable. I don't want to use this platform for debate. The third item is about the forensic examination need to be conducted in the presence of the device owner and also an independent forensic professional. Now, if we have to talk the reality, while the criminals have automated their perpetration, whatever crimes they are perpetrating, it is automated. They have adopted AIMA and all. Unfortunately, the investigation part, we are still in a manual process. So it is very unreasonable to expect the investigation agency to match the criminal competency or capability with respect to handling this thing. So I think days to come, the privacy angle is already taken care by the enforcement authorities. I think much more stricter documentation, all those things will be there in the future.
Yeah. So good that you brought the point about documentation. That is when I come back to you, Akshaya. So can you help me identify the role of data fiduciary versus the data processing, and how documentation becomes key and can help digital forensics get the data that they want? Because as you rightly said, we have access to the instrument but don't know what to look for. So what is the role of fiduciary, and what is the norms on data processing that is there in the DPDP Act, which makes it more transparent for forensics personnel like Venkatesh Murthy to access the right kind of data?
Sure. So let me first explain what these terms are. So what's a data fiduciary? What is a data processor? So under this new law that we're expecting will be in force soon, there are a number of stakeholders when it comes to a piece of data. Let's say there's my name, that's the personal data. The name belongs to me, so I am the data principal. Now let's say that there's a company which is selling certain products and they want my name to be able to sell the product to me, to be able to create an account for me, say on their website, and they want some other information about me, for example, my birthday, to give me a special offer around that period. So because this company that's selling the product is determining how to use my personal data and for what purpose, right? It's determining the means and purposes of processing my data. They will be called a data fiduciary. And let's take an example where this company is engaging a logistics provider to actually deliver the product to my house. This particular company only needs my name and my address and maybe my phone number to contact me. And they only need it for delivering the product to my house. So this is a service they are providing to the data fiduciary. So they are called a data processor. This is a very simple explanation of these three stakeholders. What the new law does is it holds the data fiduciary as the entity which is entirely responsible for the safety of the data and for complying with the data. So there are a number, for example, if you think about technical safeguards, organizational measures, security standards, these need to be ensured by the data fiduciary, and they can impose these obligations on a data processor. For example, in the example that I gave you, if the data fiduciary is the one that's processing my personal information to sell me a product, and they engage a logistics company, they can require that the logistics company delete my data immediately after the product is delivered to me, and they don't use it separately to target advertisements to me, as an example. So these are the ways in which data fiduciaries can provide certain guidelines to data processors to ensure that data is safely maintained. On your question on investigations, the new law actually, like I said, consent is the main basis and there are certain other bases for processing. But these requirements can be circumvented in certain situations. For example, if you want to prevent, detect, investigate a criminal offense, then a number of the compliances under the law will not apply. So in those situations, the law empowers an organization to be able to access data even if a person doesn't consent. However, when you can say that an investigation has begun is something that remains to be tested, because an organization can't potentially argue that at any given point I am looking for a potential crime or an offense that can occur. So there potentially has to be a nexus between a suspected offense and the act of investigation.
Great. I think we will have to wait for the outcome of those two petitions that are pending before the Apex Court. I think that will clarify a lot of things on what extent consent is required to access data. Well, data is one that kills people and also makes more money. So Hemant, tell me, what are the challenges from the organization side? Because as an individual, I may log in and share data that is strictly quote unquote personal to me out there. But then what are the challenges that organizations that host these data face in ensuring the privacy of this data or protecting the personal data that is there?
Yeah, so good question, and this is exactly what clients have been asking people like Akshaya and me for the last 1 year. There is a joke in the privacy circles, and it is that how many privacy lawyers do you need to change a light bulb? Any guesses? The answer is no one knows, because no one got past the privacy impact assessment. So I think to begin with, a lot of organizations, and because the SPDI rules that currently are prevalent are not very restrictive, do not contemplate fines that would give sleepless nights to people. India is not a very data privacy compliant country in general as of now. But in all likelihood, and hopefully, knock on wood, if it's implemented right, that's likely to change. In which case, I think one of the biggest pieces of impact would be that organizations will now first have to take stock of all the personal data they've already collected. And the new law asks all organizations to ensure that they sort of re-authenticate the data that they've collected, personal data, and ensure that their continued use of it and processing of it is consented to by users to whom it belongs. In a lot of the cases, organizations might no longer have information on why they collected that data and so on, right? And when they should get rid of it. So that's not likely to be an easy task. Akshay already pointed out the difference between a fiduciary and a processor. But that distinction also might get blurry in a few cases, because technically a data fiduciary is somebody who determines the means and purpose of processing. But take, for instance, someone like a payment aggregator, okay? They are not the e-commerce platform which is collecting the data of the user at the first point, nor are they the sellers or the merchants who are shipping the goods. Now, let's say I'm a payment aggregator. I've given the payment gateway and, I take payments into my account and ensure that those are routed to the merchants. If I use somebody's data to determine that, okay, I am going to use this data to pick this particular way of splitting payments as opposed to this particular way of splitting payments. Or I'm now going to use the personal data of this person to process a refund, which has to be processed using, you know, certain contractual arrangements and some RBI guidelines. Again, when it comes to each of these decisions, there are multiple ways of doing it. You know, just to give you a very sort of dumbed down example, I can choose payment gateway X or payment gateway Y. I may use account with bank A or bank B. Now, does this, and you know, how I process the data? I can process the data using, you know, software X or software Y. Will those kind of things, and when the payment aggregators don't really have the opportunity to collect consent themselves, should they look at themselves as fiduciaries or processors? Quite a tricky one. Sure. Likewise, you know, there is stuff around employment. Basically, under the new law, there are two broad grounds on which you can process data. One is consent, and second is some legitimate grounds that the law already contemplates, right? One of those legitimate grounds is employment. So you can process somebody's data in connection with their employment, provided they're an employee. But then, you know, organizations get job applications from people who are not yet their employees. Correct. So can they process the data of these employees without, you know, taking an additional specific consent for the purposes for which they are going to process it? Likewise, there's stuff around, you know, children's data. Now, you're not supposed to process children's data unless you have verifiable parental consent of that child. Now, this could potentially mean that every single user of your app or your software or your service will have to be age verified to make sure that you're not dealing with a child. Correct. Right? And then if you want to, even assuming that you want to, how are you going to do it? Are you going to rely on a self-declaration? Are you going to take ID? Are you going to rely on biometrics? That's an entire rabbit hole, right? So there are a lot of ambiguities that will still sort of play out. And I think organizations, to begin with, should ask themselves the basic questions. What data do we have? What is the purpose for which we want to use it? Right. How are we using it? You know, where are we processing it? Using which third parties? And look at their contractual arrangements with the third parties. See if they are protected for, you know, breaches and defaults committed by counterparties in the contracts. I think, and devise what, you know, we typically call a privacy by design, you know, policy. So that privacy is not an afterthought, so that when a breach has happened, you're not flying by the seat of your pants, but you've already, you know, become cognizant of potential risks that exist in relation to data, and you've taken a policy, it's already in place, there's an incident response system, all of that. I think at a minimum, doing that will ensure that an organization will do pretty well on the data front, even if the law was to take effect, you know, very soon.
I understand, because my daughter is moving from one stage of her education to another. Surprisingly, you know, before it dawned on me that she's ready to take that access, I had call from some of the edutech companies saying, do you want to enroll your kid? But I have not shared it. So where did this data come from? Okay, so there are a lot of these questions on how free are the organizations to share these kind of data to people. I think only the enactment and coming in of the rules and implementation of these will throw some light. But I have a background light from my MC who's already, you know, traversed twice back and forth saying the alarm is up, boss, you need to conclude. So there is a legal maxim that says vigilantibus non dormantibus jura subvenient. In lay English, what it means is the justice comes to only those who are jurisprudence or who are aware of what their rights are. So next time you come across such portals, such process where you need to share data, I am sure the audience here will have that forethought of why am I sharing this data, for what purpose is it going to be used, or for the organization who are sitting here in startups who want to encash and ride on this rich data that is there, how am I going to collect this data? How am I going to utilize this data? Data storage, handling, and deletion. You know, it's not just storing, but deletion becomes a and who can delete this data? I think if there was some time, probably Venkatesh would have thrown light on the right to delete, and to what extent it can be implemented. But let me throw the floor open for some questions from audience. I know it's time to wake them up because there is tea waiting at the end of the session, I know. But if we can have other stimulants for the brain in form of questions, I think we would like to take 2, 3, MC. Number of questions allowed for us? Yeah.
Hello? Yeah. Question number 1, right here.
Yeah, please introduce yourself and pose the question.
Yes, sir. Myself, Sushma KS. I'm from Global Academy of Technology, Assistant Professor at the ECE Department. My question is, to maintain the privacy of the data, is there any specific rules made under this new law which has to be followed by the citizens of India?
Okay.
Because we speak about the privacy, data privacy, right? So any rules made under this new law that has to be mandatorily followed by the citizens?
Hemant, Akshaya.
So under the new law, there are some obligations on, making sure that you're not misrepresenting your data. But the objective of the law is not so much to make it onerous for individuals like you and me to manage our data so much. It's more about, it deals with processing of personal data. Ultimately, it's up to you and me to look at our own personal data as an asset that belongs to us, just like you would look at, something that you own in terms of material property or intangible property, let's say patents, for example, right? So data is an asset. It's sometimes intangible. But beyond that, the concern of the new law is not so much on making it mandatory for individuals like you and me to conserve and protect and secure our data. It's on ensuring that organizations that process our data are prudent, cautious, they are not taking liberties with what they do with that data to ensure that that value associated with our personal data remains. Does that explain?
Okay, next question, please.
Question is to Mr. Venkatesh Murthy. I'm Murlidhara. I'm a professor in the Department of Computer Science. There are 4 different acts which I would like to bring in here. One is Aadhaar Act 2016, RT Act 2005, Right to Information Act 2008, and then Data Protection Act 2023. There were, RTI Act clearly says that to a government agency or any such agencies that mandatorily you have to disclose certain things. And then the Aadhaar Act 2016 also says that how do you protect the information which you have collected in the Aadhaar in 2016. And the IT Act also gives a clear direction, as you rightly mentioned, that it gives provisions in 43(1), and then it also has a provision in 72. And then 78 also says how do you investigate, and then who are the people who can investigate, and so on and so forth. Now, when you are looking at this Data Protection Act 2023, I find that there is a lot of redundancy. Now, suppose if I want to go and give a complaint, as you rightly said, that an inspector can actually investigate, and then he knows how to keep my data. Now, when I give some data, when I go and give a complaint to a police officer saying that my data has been not protected by an X or Y or whatever agency which I'm looking at it. It could be my data related to my biometrics, which has been stored in Aadhaar. It could be related to other kind of information.
Sorry to interrupt.
So how
if
do you?
A question that is coming, it would be useful.
Yeah. How do you actually relate all this? Do you think that there could be some kind of redundancy in implementing this, especially by a person who is actually mandating this?
Yeah, I think the DPDP Act, entire DPDP Act, the purpose of DPDP Act is not to criminalize any of the whatever data breach or failure to preserve the privacy. So when it comes to the breach of your personal information, so police, as of today, the Information Technology Act talks about say Section 66 read with 43, which is computer-related offences. So you need to look at Section 43 connecting with Section 66. When there is mens rea, when the intention is fraudulent and dishonest, so then there are certain acts that are mentioned in Section 43, like the 43, it starts like this: whoever without permission of the owner of a computer system or computer network, A, accesses, B, downloads, deletes, extracts any information residing in a computer resource, introduces any computer contaminant. All those offenses are very well listed. So unlike the other areas like where the body corporate who is processing the information, if there is a breach, so IT Act clearly mentions that there are two very important ingredients. One is the safe security practices and due diligence. So the body corporate, whoever is processing that information, they need to showcase that they have followed some safe security practices and also they have exercised due diligence. So those things will be covered differently. But when it comes to police investigations would come in place only when there is a unauthorized access. The breach has taken place after it was accessed unauthorizedly. So then the hacking and all the provisions would come into place. So police investigation, they are more concerned about if there is any unauthorized access or exceeding the access. Only then the police investigation will take place. Otherwise, then it cannot be called as cyber crimes under the Information Technology Act. It can be called as cyber contraventions. Cyber contraventions are dealt by the adjudicating authority under the Act. This is my understanding.
Okay.
If you want to add.
Yeah. Question?
Hi, my name is Venkat. I'm the CISO for my company. My question is, will the DPDP Act ever be as good as the GDPR? Ever?
Yeah.
I'm not sure who can answer that, but I guess all of you can
Yeah,
try.
I'm sure everybody can answer, but we'll let Akshaya do that.
Thanks for the question. I think what the DPDP Act can do for the protection of data in India and ensuring that we still have, we're able to enable businesses to process data meaningfully to be able to offer products and services to persons in India is quite immense. I wouldn't say that the DPDP Act is not as good as the GDPR or is better than the GDPR. The way that I think about it is what are the principles behind the GDPR, right? The way that the GDPR approaches data is there's a uniform principle applicable to data, and then for certain categories of sensitive data, it applies a certain different standard. What the DPDP Act does, however, it applies standards uniformly across all kinds of data. So from an individual's perspective, I know for a fact that whatever data a company has collected about me, it needs to be protected. Whether it's organizational measures or technical standards, security safeguards, they need to be applied to any data that the company has about me. From a company's perspective, this is helpful because I don't need to have separate practices for different kinds of data. I can have one set of standards that can uniformly apply across whatever kinds of data I collect. And I can draw similarities between the GDPR and Data Protection Act, where there may be differences in the way that the acts are drafted or what they seek to regulate, but what is in the DPDP Act could actually be beneficial in the Indian scenario and could help us. I'm keeping it really brief in the interest of time. But I'd be happy to go through multiple examples if required.
No, the MC is already staring at us, so can't.
All right. I hope that answers your question.
Yeah.
No, such an insightful discussion. I think the
Do
panel.
we have a moment to conclude?
Absolutely.
And then let the floor to you. Thank you so much.
Absolutely,
So, thanks for letting us conclude this wonderful panel discussion. I immensely thank Venkatesh, Akshaya, and Hemant. You know, I've made beautiful friends also with them now, part of this. So it is Gary Kovacs who says privacy is not an option, and it shouldn't be the price we accept for getting on the internet. No, and anyone who steps back for a minute and observes our modern digital world might conclude that we have destroyed our privacy in exchange for convenience and false security. But it is more the awareness that we need to bring into ourselves on how we share the data, and rather than being a consuming society, be a consumer-driven society, where we make the organizations be responsible for the data that we are sharing with them. You know, in Kannada there is a saying that says "Matu Belli Mona Bangara." Translating it to today's topic, it would be "Data Belli, Privacy Bangara." So if you remember that, I think all our lives will be wonderful. Thank you so much for this opportunity. Over to you.